Hello and welcome to another episode of Litigators Corner, and I am happy to have with me Malcolm McNeil, who is an international lawyer and who really has met James Bond. Malcolm, welcome. Thank you for coming today.
Thank you for having me, Hillary. It's my pleasure.
Okay. Malcolm, tell us about yourself and what you do.
Sure. I'm a partner at Arent Fox, a law firm that has 5 offices in the U.S. I've been practicing law a little over 30 years. I say a little over, being generous to myself. I am the international co-leader of our firm for the West Coast. That's for the LA and San Francisco offices. And basically what that means is I have my own practice, of course, but when things come in from an international perspective, whatever it may be, whether it's litigation or not, it comes through me and we decide how it's going to be staffed. And that can mean you have to be versatile because international hides a lot of practice areas. It also means that we have internal training, which I do for the associates, which is interesting, teaching them a variety of skills.
And that would include litigation, transactions, and I know that you also are involved in some international arbitrations, and that we've had conversations about that as well.
Yes, I'm privileged to be an arbitrator, a listed arbitrator for 3 Chinese arbitration associations, the Beijing International Arbitration Commission, the Harbin International Arbitration Commission in northern China, and then in southern China for the Shenzhen International Arbitration Commission.
And you, Malcolm, you have a career, I think, that's a lot of people can only dream of. You get to travel internationally. You get to meet amazing and famous people. You get to work on interesting cases. How did you get your start in international law? I'm curious.
Well, I'll give you, this allows me an opportunity, Hillary, to explain why I have 007 in the background. I was an international fan and a Bond fan at an early age, and it did end up causing me to decide that whatever I wanted to do it internationally. And I had a love of the law. I didn't want to be a spy, but I did want to travel. So I left a large law firm a year out of law school and started my own office. And against all advice, I went to the airport area and had my office on Century Boulevard, represented a freight forwarder and a custom house broker, and joined the local Chamber of Commerce in Westchester. And from there, within 2 years, I had an international clientele. The only other lawyer that was part of it was a customs broker, but I started doing immediately litigation work, regulatory work. And we're talking about at a time that was pre-internet. So it was very challenging, and I was learning on the job.
Well, you've certainly succeeded in doing that. As I understand, you've met at least 2 James Bond and the James Bond.
Yes, I have. My passion for the law is equaled with my passion for the James Bond movies. I just finished a international James Bond trivia contest, not as a contestant, but as an examiner on Saturday morning. So I have a James Bond museum at home. So that all of those things. It's great, by the way, for international client development. It's not trivial to be participating as a Bond fan, because wherever I've gone in the world, people know James Bond. I can go to China, Hong Kong, Russia. I've been to Latvia, Finland. Whenever you mention James Bond, everybody knows who he is. So it's a great conversation starter.
I bet it is. And they don't let you play the trivia contest anymore because you win all the time.
Yes, I've been banned. It's sort of like being a world-class poker player. They won't let you into the casinos. Now they won't let me. My picture is there with a line through the picture, not letting me join.
Okay. And you are also very active in a lot of international bar associations. I know we've talked about what you think are the essentials, because essentials for an international lawyer. And what would you let's talk a bit about?
Yes. Well, as we speak, by the way, right now, we have the International Bar Association annual meeting taking place. And of course, this year, because of COVID, it is being done virtually. And they've stretched out the conference. Normally, it takes place about 5 days. And the IBA, as it's known, holds its meetings in a variety of cities around the world. Last year, I was a speaker in South Korea, and they took us to the DMZ, which was interesting, which I was also able to consider a tour to a James Bond scene from Die Another Day. So whenever I go anywhere in the world, I make sure that there's some tie-in to Bond. But the IBA is the one to is the they call themselves the premier bar association, and I think they are. But my personal preference for lawyers under 45 is AIJA, AIJA, which is the International Young Lawyers Association. I'm a past president, so I have to give them a special mention.
And what kind of involvement can new lawyers reasonably expect in these bar associations? For example, you really want to get in, maybe you're a James Bond fan, or how would you encourage or talk to an international lawyer about getting involved in this line of work?
I've done it my entire career. When I was on my own in my own office, even before I joined a larger firm, I was always encouraging everyone to be internationally involved and I started with AIJA as introduced to the association, and I didn't travel for 5 years. I was too busy running the practice and all of that, but I started keeping up to date. I started reading all of the things that were happening internationally. I started learning about international arbitration tribunals, EU law and the development of EU law, the development of government processes in South America, the emerging China at that time. And so what happened is that all of those things cause you to become what I call internationally minded. And that's a large part of the practice. You need to be able to think outside of your own jurisdiction and your own region. And the way that you do it is by keeping an eye on what world events are. If I have something come in from overseas, I may not even have had a direct contact with that sector or that country, but I'm already able to start to assess what the issues are that are going to arise in connection with that case because of that international framework in thinking.
I had a question about professional etiquette. My godfather has a firm in Manhattan, as we mentioned, is also an international lawyer, and just traveling with him as his goddaughter and presenting, there are a lot of etiquette issues that come up about how to present yourself with a particular culture, what you can and can't say. And, I've certainly had instances in even professional settings where a person thinks they're being polite and saying something is fine and the other person's offended. What do you recommend? What did you personally do to immerse yourself learning about that and being sensitive to different cultures? And what do you recommend that people, at a minimum, skill sets that they would have or that they develop?
Well, that's an excellent question. And the answer is that if you were about to go and make a presentation, let's say to a potential client regarding a case, you'd spend as much time as you could learning to know that client, what the nature of the business is, or who that person is, what their background is, if it's an individual. And so you actually spend time getting to know them so that you can be responsive to questions in a very respectful and understandable and personable way. It's the same thing with traveling internationally. When I was in South Korea, I have colleagues that I know with firms in South Korea, and ahead of time I would and it just so happens that I've had other clients from Korea who have visited here in the U.S., and I've learned their mores and their habits and what is the appropriate thing to do. It's very let's say it's a learning experience, because I can tell you that when my first clients came from China in the 1990s, and I had a delegation come here, and I was handling a dumping case in California that was in Washington, D.C., and I had 5 lawyers, and I'm with these large firms that are doing exclusively anti-dumping cases and trade cases, and I was trying to do everything quite right, and I was learning everything, and they said, let's go to dinner tonight. And I said, sure, we're all going to go to dinner. And then the question is, where do you take a Chinese delegation for dinner? To a Chinese restaurant? Do you take them? What would you do? So I mean, it sounds almost patronizing, doesn't it? But you need to know the members of your delegation. And I decided to do what I learned later was very good. I had my own judgment at that time and said, I think I'll take him to a steakhouse. So we went to a steakhouse, and it was a big hit. But I'm going to tell you, I was on a razor blade's edge, and I was going to say, why am I taking a Chinese delegation to Chinese food, even though that was the first choice? Now, I've done it and since then, but what I'm saying is these are the little things that you need to be thinking about and be perceptive to in order to not send the wrong message to your friends that are coming here from overseas.
Right, and it's been my experience that certain international law is certainly more limited than yours. That sometimes they have very definite ideas about what they want to see. They want to go do this, or they're very excited because they think this is something they really wanted to do in America. And if you can find those things, that also goes over there.
Well, yeah, you have to learn to abandon your own. I don't want to say prejudices because that's the wrong word, but you have to abandon your own perceptions. For example, in the middle of the delegation, I never would have said in the beginning, would you like to go to Las Vegas and would you like to go to Disneyland? I just didn't feel that. I thought that might be perhaps trivial or inconsequential, but every delegation that came here thereafter, I was planning trips to Disneyland and to Las Vegas and to San Francisco and to other notable places. But in other words, our concept of what might not be, let's say, appropriate, no, it's what's quite, if you step into the shoes of the traveler coming here for the first time to the US, it makes perfect sense. They wanted to go to Disneyland, they wanted to go to Vegas. So you need to be able to step out of your own shoes in your own, let's say, cultural cement and say, what would they like to do? A very good example in reverse is that I'd always heard about Tivoli Gardens in Copenhagen, and I wanted to go. And it was funny. I was there for a case involving a freighter that sunk, and and there was insurance claims back. A very complicated case. Met with the clients. They said, "We're going to go to dinner. Is there anything you'd like to do?" And I said, "Yeah, I'd like to go to Tivoli Gardens." And they were like, "Tivoli Gardens?" In other words, for them, it was their equivalent of, let's say, a dated Disneyland. But we went to the garden, we had drinks, we had large beers and walked around. In other words, they were, let's say, I don't want to say embarrassed, but they were like that. They wanted to take me to a nightclub or something like that.
Right.
But then they realized, well, no, he wants to go to Tivoli Gardens. There's nothing wrong with that, even though they sort of keep it on the back burner for themselves.
It'll be like this. Yeah. Well, you go to Paris, you probably want to see the Eiffel Tower if you've never been. You probably want to go see. You go to New York, you probably want to see the Statue of Liberty or a lot of other things you would want to see. So it makes sense that all these people would want to see those things. But it's good that you were working with people who are sensitive to that and didn't just have an itinerary that was kind of missed what they would want. So that's.
I mean that's what it is. I mean, we mustn't be we must be culturally attuned, but I'll also tell you that being culturally attuned doesn't mean that you have to engage in a language immersion project every time you're going to go somewhere. If you're able to learn a few words, by the way, when I was president of IESA, which was it was in 2000, IESA is they're based in Brussels, but they have meetings all over the place. And during the presidential year, every 6 weeks I was traveling from LA to somewhere in Europe, and one of the meetings was in India, and another one was in Lebanon, and I would give part of my speech, about like 2 or 3 paragraphs, not paragraphs, excuse me, I'm saying too much, 2 or 3 sentences, and I would take those sentences and then I would, and my favorite line was, "I'll now revert to English." And that was good enough. It wasn't required that I give an entire speech. I would always get a very polite applause. Except when in one case I was accused of calling the leader of the country a pig dog. No, I'm joking. But you have to be careful of your translations. Okay.
Yeah.
But the point is that shows the respect, but you don't have to go overboard in terms of that respect. An acknowledgement of those local mores and sensibilities are important.
Unless that's an area of interest to you. I know.
Of course.
I know that we had talked about, but that's great that you do that and that you're I mean, I just don't think obviously you're a very successful international lawyer, but I don't think any international lawyer can be successful without understanding that, or anybody who does, particularly in this day and age. So, Malcolm, when you get a new client who's calling you for the first time, I know that we've talked about the fact that there's a big unknown factor for international litigants about our system. What do you talk to your clients about when they first call you and to assure them?
Well, that's a good question because it sort of is a 1, 2, 3. I want to assure them that they're going to get their day in court. I want to assure them that our system is as fair as we can expect. I want to assure them a lot of them worry that it's cases are going to go on for 5 or 10 years, and I say, well, no, not really. At least here in California, we have certain restrictions. It won't happen, and chances are you're not going to go to trial. 90% of our cases settle. So, but let's look at your case. The reason why that's important is because clients are usually referred to me by their lawyers locally, and the local lawyer is asking me for a budget. And when they see the trial budget portion of the budget, they go crazy because it's like, why is it going to cost so much? So I try and explain that no, number one, don't worry about that. Number two is it is expensive to litigate in the US, primarily because of our expansive and exhaustive discovery process. And also I caution them and tell them, look, keep control of your records, because the good thing is these rules apply to both sides. So if you do what you're supposed to be doing, then the other side is going to be expending money too, and that's going to help you settle the case. So that's one of the things that I do to try and control the sticker shock of litigating in the U.S.
And the initial panic that's probably sets in soon after about how much this is going to cost.
The answer is absolutely, and I've been in beauty contests with other lawyers who are quoting costs, etc. And I've seen those budgets, and they've usually exceeded mine. And the only reason for that is my budget is comes from a place where I did have my own practice, and these are small to medium-sized clients who are looking at what it's going to cost, and they really want you to sharpen the pencil, not just give broad strokes as to, 20 hours for this and 40 hours for that, because then it looks like at the end of the day, they have 500 hours on a budget and it really doesn't explain how that money is going to be spent. But yes, the sticker shock is, that's how I soften the sticker shock so that it's more, they need to be able to explain it to their clients at the end of the day. So I try and explain it in a counsel to counsel way, knowing that I'm not convincing counsel, knowing the counsel has to convince their client.
And do you often work with Kumas Council in these situations as well?
Yeah, not so much in the international arena, but I work as Kumas Council, and I work as Kumas Council. I have right now a boiler that exploded in a casino, and there's an issue about intentionality, and so I'm now shadowing that case and but I'm shadowing it in a good way, meaning that I talk to counsel. I don't want them to think I'm looking over their shoulder. I don't want them to think that I collaborate. I've learned a long time ago when I was on when you're on your own, you have 5 lawyers, we all run into rough characters who are opposing counsel, right? I've learned that you can control some of that by your own demeanor and how you deal with opposing counsel. And I'll tell you, most of the time, I'm getting along pretty well with opposing counsel as well as co-counsel, because many cases have, as we all know, co-defendants. So you need to be getting along and not one-upping each other and not making sure you communicate. And that's the rule that I tell my associates that they must do. I find a lot of lawyers send letters back and forth, but the clients don't necessarily see all of the tennis game that goes on between counsel. And I tell the associates, send it to the client. Just say, for your information. Let them see it. That way they know that you're working, because the tree doesn't make a noise if you don't hear it fall. So
that's true. And I think, traditionally there was the perception, particularly if you're in litigation or may head to litigation, that the person who's the loudest and is the meanest is going to win. And I have not ever thought, I'm not talking about setting boundaries and being tough when you have to. I've never thought that approach really works particularly well. I mean, I think any attorney worth their salt is not going to be impressed by that. And really all you're going to do is people are going to go, okay, yeah, I remember that guy who was screaming about something.
I agree with you, and I guess I'll give it one. I fully agree with you, because I was going to say a however, but I don't want to really do a however. I've added to that rule, and I've said that I've told the associates, you at all times be respectful and professional and do all those things that we've learned in terms of our civility and so forth. But that doesn't mean that we are automatons as to how we respond. So if somebody is very nice, we respond one way, we respond in this fashion. And if they're very mean, we respond in the same fashion. And I've
Right.
said, no, it's okay to tell them off. Okay, I said, if you find the counsel is being rude or insulting or yelling or abrasive, you have the right to elevate your game. Not to elevate your game to match them and be just as rude and abrasive, but certainly to raise your game to let them know that I know I'm on to you and what you're doing, and don't always just feel that you're constricted to one temperature in your response to bad behavior. And and it takes judgment. One of the hardest things of all is we need to exercise judgment and not always do things routinely as lawyers, and that's how we get the best results for our clients.
I've always thought one of the best things about being a lawyer is you can tell someone to blow off, and paid well for it. So I'm a big fan of that. And I agree that there are certain ways to say, hey, we don't do business that way. And there are different tones depending upon your style that you can use, where you don't have to demean yourself, frankly, and start screaming and things like that, and to handle situations like that. So I agree, there is no one size fits all. And sometimes, if you're reading the book of protocol or whatever, it may not be in there. But that's always also when there is conflict. I think sometimes that's a good way to assert your own style and make it yours as a lawyer. That's sort of
I fully agreed, and I'm on the attorney settlement panel for USDC Central here, and it's very interesting because in that process I met some very fine lawyers, watching them in a mediation setting, and I've actually learned from their skills during a mediation. In other cases, I've been very surprised at bad behavior during a mediation, really totally unmediative, and then you have to go in and counsel them. But it's a different kind of counseling because I'm not opposing counsel. I'm a mediator and not wanting to offend anyone. But at the same time, you need to be firm and say, counsel, your approach is certainly not working right now. I can fix this for you a little bit, but you have to work with me, and so again, I think the key is being prepared to step up without overstepping. That's the phrase that I've used: step up, but don't overstep.
No, I think so. What is your advice to attorneys when they go into a courtroom or actually, let's start with an international arbitration. There is, people are watching when you're live or you're on, and most people, and that's why a lot of people don't like to get into litigation arbitration, because they don't like the stress of it, but other people love it and gravitate towards it. When you're going into an international setting, in an international arbitration or trial, what do you generally, you've got to do your homework, you've got to do this. What do you suggest would be your demeanor? Because my feeling is it would be very different from here, where you're outside, particularly if the media is involved and we're going to look a certain way. The Hollywood look may not work in other settings. What do you advise an attorney in that situation?
Well, I can give you the trite answer, which is be prepared. But let me fill that out a little bit in the international context. I've had 6 overseas arbitrations now in my career, in the UK, China, Singapore, Hong Kong, and Geneva. And in those arbitrations, the good thing about arbitration is you tend to learn a lot more about arbitrators than you even would here doing your background check on a judge, because we've all seen the Daily Journal profiles of our judicial officers, but overseas, but the arbitrators usually have very exhaustive backgrounds, and the reason why they do that is that those backgrounds are also PR tools for their next arbitration. So you can learn a lot about them. And I've also requested, even when arbitrators are a little bit less, they want to hold a short meeting regarding how the process is going to take place, or in an arbitration status conference, I've tried to lengthen those a bit, learn a little bit more, and let them know me. I've tried to impart a little bit of my personality so that because arbitrators are in the same position. They're looking at counsel, not knowing whether or not counsel are going to be getting along, whether or not counsel are fighting, whether or not they're going to be prepared. And the arbitrators and the additional, let's say, attribute that they have is they want to be very professional, and also they don't want to antagonize anyone either, for a variety of reasons that we know about. So I try to make sure that those arbitrators understand me ahead of time, what they can expect from me, so that their, let's say, apprehension level going into an arbitration is lower. And I've been overly gregarious, overly friendly. Hi, how are you? Ms. Johns, I've read a lot about you. Good to meet you. Okay. Not, not butt kissing, if we want to say it, but showing that I've done my homework. I've learned a lot of, I heard about the Smith versus Jones case. And yeah, thank you. And thank you for the time you've given us ahead of time to prepare for this. In other words, let them know that they don't have to be on guard for me. And that's the first thing that I've learned is very important in international arbitration. And one of the reasons is that lawyers that exclusively do arbitration, I found, do tend to be a little bit, in some cases, they tend to be a little bit too officious with the arbitrators. In other words, showing that they know how much they know about the arbitration, so that then makes the arbitrator a little bit more anxious.
It sounds like you've developed a style that puts people at ease while still being professional, which is, I would think, would be the ideal.
It is. It is. I mean, even though we know that arbitration is a little less stressful than litigation, there's still stress, right? You're antagonist at a table with somebody who's going to be deciding things. You're trying to control the environment. So yes, the more that you can control the everybody being anxious, the easier it is that you can focus on your case, your line of questioning, the argument, responding to opposing counsel, because I'm not worried about somebody next to me or somebody else, getting out of control by something that I've said or something like that.
Right. And what role do you think the ability to control the courtroom and having the right style, how much impact do you think that has on?
I won't put it into percentages, but I will say a significant impact. I was in a conservatorship several years ago, which was hotly contentious with three clients, but there were four siblings, and they were fighting over an issue of undue influence, and the sibling who was causing the undue influence on the father, his lawyer was constantly misrepresenting to the court. And I would interrupt. Okay, we all know we do not interrupt, but I would interrupt, but in a manner with a very, that's not true, Your Honor. You know that from the November 10th hearing. So in other words, in a way, so later, after we had several hearings on this case, because it was highly, highly contentious, the judge, she would take a look at the case and go, well, I see, okay, we're back in court now on the conservatorship. But Mr. McNeil, what's going on?
Oh, because she knew you'd be straight with her.
Exactly. She knew that she could rely on what I said. And I feel that is so critical, because I've been a judge pro tem, and I know that if you feel that it's like a jury, right, Hillary? I mean, if a jury thinks that you're playing games with them, or you're thinking that they're dumb, or that you're going to pull one over, the jury's going to get angry and they're going to punish someone for that. And
they are.
Exactly.
Well, particularly when you have a judge with a busy docket, and particularly in this day and age, when if you do go actually physically go into court, you're putting your life at risk every time you go to work.
Yes. Well, and I've also learned to be able to push back on clients that want you to talk about or issues that we see as insignificant. I mean, that's one of the hardest parts of our job, right? For us to be able to say, somebody thinks that a witness is indispensable, or I need you to look at this document and the note that was written on the napkin, and you're like, and you know that in the grand scheme of things is simply not going to have any impact. But you need to be able to push back in a way that the client doesn't feel that I didn't get justice because they never discussed the napkin notes, and so those kinds of things, you need to be able to balance those, and I usually balance it by saying you don't want to lose credibility with the judicial officer. You can't focus on those little things. The judge will think you're wasting time. The judge is going to become intemperate, and if that happens, you're going to lose the case.
Right. And I've had that happen to me recently. And actually, one of my clients was actually a professional expert, but really wanted, in his case, I'm like, I don't do it. I'm like, all right. I gave him 10 minutes to talk on his issue. I said, Your Honor, my client really feels he needs to speak here. She's like, all right. And she says, and she looked at me and she goes, none of that was helpful. I'm like, all right, well, none of that. I think, Your Honor. And I kind of knew that was going to happen, but it was a bench trial. She was very fair in the ruling. So there wasn't before a jury, but he felt like he had had his say. He felt the judge did not like it. I don't think it helped him at all. It didn't hurt him, but it didn't help him. But the judge was like, wasn't helpful. Gotta go. No, but at least he heard it. And that was a professional testifier. He flies around the country to do that.
Yeah, well, yeah, and that's unfortunate because you would think that with some experience, people would, modify their behavior accordingly. Yeah, I mean, I that's why I like judicial officers who have been in practice, with real clients. You know what I mean by that is not necessarily somebody from the DA's office or the public defender's office, or that you learn people that have had, and maybe, but just a judicial officer who's had experience with clients and those things, so they know that sometimes you have to let things go, and because you're required to do so as counsel for that party, so that they don't hold that against you.
And some judges will say, we've all been there, Your Honor. I know I have to present this for my client, or and sometimes judges will take you in. I don't know if they do it. Do they do this as much in international tribunals? Sometimes the judge's like, I want to talk to the attorneys. Will they do this in international arbitrations? Or is it a more formal, or is it depend?
More once it starts, it's more formal. Yeah.
Do they have, like, for example, do they have private meetings with these? Because in the U.S., they'll just call you up and they'll say, hey, I want to talk to the lawyers. You'll get a call or an email. When are you guys free to talk? Okay, can I call you tomorrow? I'm assuming it's more formal.
It's more formal because, I think one of the issues is that impartiality issue they're worried about more than in other cases. And when you're a stranger in a strange land kind of thing, everybody wants to make sure that everybody feels that everybody's on the same playing field, and so they're a little bit more formalized once the process begins. But what they've done, I've seen it was just kind of break and speak with counsel privately, and then we'll agree. And it was like, this witness that's testifying right now is not really helping anything. Can't we move on? Okay, and arbitrators get a lot of let's say criticism because there clearly is an issue that arbitrators want to be rehired for future arbitrations, etc. But I've not really run into cases where arbitrators have unduly and excessively allowed an arbitration that should go 5 days go on for 3 weeks. There is pressure on arbitrators, as you may know, under the rules. One of the rules for overturning an arbitration is excluding evidence that should have been listened to, but it doesn't work the other way around. The arbitrators can listen to a lot of evidence that we couldn't bring in a court of law in the United States. So there's a lot of latitude on presenting evidence, but the problem with that is it lengthens the proceedings. So I argue a lot about that issue with arbitrators, and I don't always win because they know that if they agree with me and exclude something, it might be grounds for reversal.
Yes, that might be the one fact that they should have let in, and then they're going to have to do it all over again, and then they get the reputation of being overturned and things like that. What advice would you give to anybody who's going into an international tribunal these days?
There's a really basic one, which is going to sound pretty trite in and of itself, but know the rules of the tribunal. I mean, it is amazing how many people go into, they don't know what Rule 21 is, or, you know, basic rules of civil procedure in a federal courthouse. If you're going into a federal courthouse, you know those rules, right? You don't want to be
Right,
by
right.
the judge. And but in arbitration, they say, oh, well, it's an arbitration. So I guess the rules are all the same. And the answer is they're not. I mean, I can tell you specifically speaking of the Beijing International Arbitration Commission, which is BIAC versus CTAC, which is the older arbitration commission in China. The
Mhm.
rules are very different in terms of what to do if there's a deadlock on how to appoint an arbitrator. How do you overcome that? What kind of privacy issues exist behind the scenes in terms of struggles, et cetera. So the starting point is read the rules and make sure you understand the rules of this tribunal that you're in, because
Yeah.
they're not the same.
Yeah, no, I agree, and it's amazing to me how few people. That's the first thing you learn, even before you go to law school. What court are you in, and what are the rules, or what governing body is handling this, and what are their rules? And people come there and like, oh, you think it's just the American way, but it isn't.
Well, what happens is the good thing about it is the bad thing about it, in a sense. And the good thing about it, oh, well, this is an office or a conference room somewhere, or it's in jams, or it's in some very, you know, set up conference room somewhere. And because of the seeming informality of it, we think we don't have any rules, but we do. And they have implications at the end of the case, and along in terms of what remedies you have if something goes wrong.
where do you see international law going, particularly in the Zoom age? What have you noticed that is different about, besides that you don't have to travel anywhere, particularly for you? What have you noticed that's different about international proceedings?
Stepping back from that for a moment, I'll answer that, but I was just going to say one of the good things is that, yes, I've been traveling 4 or 5 times a year. At the end of the year last year, I told you I was in South Korea and Cyprus. My last international trip was in January to Houston. No, I'm joking. It wasn't international, of course, but that was the last time that I really traveled. And what I've learned from about February 20th on is that the need to travel overseas to see counsel or to see witnesses or those kinds of things, there's a new expectation. In other words, they don't expect me to be there to do that, whereas in the old days they did. Meaning that if you say, "Oh, when are you going to be in Beijing next?" Okay, or when are you going to be in Berlin, and so you'd have to schedule things, and it made the practice more hectic. The reset from an international perspective is, I think there is a reset in terms of those expectations of seeing you in person, and that's a good thing at the end of the day. And so, because it means we spend less time traveling, and as a consequence, we're able to be a little bit more grounded in the practice. For those of us that are international jet setters and would like to see those other places, of course, it's a different story. But in terms of the practice and what they've been doing, I've been finding that there's more. I've had three since March. I've had three status conferences on arbitrations by Zoom, and they've all gone well. Okay, we've done it by Zoom, whereas in the past it was more of a telephone conference. You'd have a telephone conference among counsel. So the arbitrators, I think, the fuddy-duddies who are arbitrators, and I hope none of them are watching this interview. Uh, they are they've come into the Zoom age. So I'm finding that our arbitrators are becoming more electronically attuned and educated, which is helpful, because if everybody is comfortable with the medium, then you're going to get a lot more accomplished. If people are fumbling around, by the way, you're going to have a different situation. I had a mediation for the federal court 2 months ago, and the lawyer on one side couldn't get the phone hooked up, and then the client couldn't hook in, and then I had the Zoom WebEx or whatever they use for federal court in front of me, and I had a client on a cell phone, and I had the lawyer on my landline, and I'm trying to make sure so everybody can hear each other, but then I had to make sure that everything is protected, obviously, because you don't want people hearing the wrong things. But the point is, in the environment, I was very comfortable with it, but I had to be very innovative there. That's how some people feel, some of the arbitrators feel. They feel that that in the beginning they were just uncomfortable with the process. Now I think they realize it's the new normal.
Yeah, it's the and it always makes it nicer if everybody's comfortable with that. But it's I have not experienced that myself, but I have heard stories of, oh, we couldn't get the sound to work. I was talking to a colleague one time. He's like, he was arraigning people. He was going to arraignments in criminal court where they still required a personal appearance, and they were trying to get the video feed set up from the prison so they didn't have to bring people in to get them arraigned, and they hadn't had it set up, so they were sitting there all day in line from like 8:30 in the morning. It was still like 2 o'clock in the afternoon when I talked to him. He's like, we haven't called their case yet.
We have a case in it's a trade secrets felony case pending in Tennessee, and the court has been very amenable to Zoom and other things, so that I have local on the ground counsel over there, but I've also been able to appear by telephone and to the court, and making sure. So that the answer is, I think even federal judges have become more relaxed about those things than they have been in the past. Now, obviously, criminal procedure is a little different because I have a case pending in Orange County right now, and it depends on the bench officer who's there as to whether or not they're saying, oh, the client can appear or not appear. As a technical matter, they're supposed to appear on a felony continuation to be ordered back, but some judges are being a little bit more relaxed about that process. Whether or not they get dinged for it because somebody appeals it and ends up getting a case dismissed is another story.
Right, and who's to say how that's going to work out with all the amendments to the Constitution and just the current environment as well. What would you say to international lawyers if you had to sum up what you feel the direction that international law is going?
Well, I'll put that into a tiny bit of perspective. I'm a local Loyola Law School grad, and when I was in law school, when I took international law seemed to be a very, very, let's say, esoteric thing, because we had courses in public-private law and all of that. And then we had a little throwaway course in the third year called International Business Transactions. And so for me, international law was never the former, because I wasn't dealing with treaty protocols and those kinds of things. I was dealing with business transactions between two countries, usually a foreign company or whatever dealing domestically in the U.S., or a foreign client here wanting to go overseas. So I think what's happened is the definition of international law has expanded. It's no longer that dusty kind of thing, but it's now international law is what I said at the outset. It's whatever comes to you that has a foreign component to it. It may be the law, it may be a party. So international law, I think, is what I would tell practitioners today is that international law is really international business law, and that's the largest part of business. And that's the largest part of international, and that the rest of it, I leave for my colleagues in Washington, D.C., who can talk about the things that are, let's say, perhaps more interesting at some level, but less of wide usage. So do it. If you're interested in the international law, the only thing I'd say is make sure people have a higher expectation that you do understand things internationally, that you're internationally minded, such as I used to read, not used to, but I still read The Economist, and I don't agree with all of its political views. Right. Okay, I quickly add, but I do read it to know what's going on because there was a coup in Ghana or whatever, just so that you're sort of internationally informed. And I think international clients have an opinion that Americans are not internationally informed. So it's important to have that mindset when you're dealing with overseas clients and counsel.
Yeah, there's certainly the perception of America that we're egocentric and probably ignorant of other cultures, or just don't think about them because we think we're the center of the universe and not. So there's.
And it's not a new phenomenon. I tell everybody, even in the last 4 years of Trump, and everybody's saying, "Oh, what's been going?" I said they've been saying that under Bush. They said it under Reagan in the '60s.
Right, yeah.
Charles de Gaulle said it. He used to always make jokes about the Americans. So yeah. It's just one of those. So we must realize, we not be too defensive about it, because I always say, well, we're Americans. You know, I talk about it. Sometimes we're talked about that. Oh, gee, most Americans are not bilingual, for example. And I said, yeah. Well, we don't really have to be that much, except in certain regions like Southern California, where we have a large Mexican American population. But in the rest of the country, where it's not like you guys here in Europe, where the Hungarians speak either German or English, and the French speak English or German. You know, it's a necessity in their environment. So I sort of try and educate in a nice way over martinis when we have those discussions.
Yeah, we have big states that are as big as your countries, and everybody there speaks English. So maybe you'll have a few people there. So there's not the necessity that there is in Europe or other countries.
You know, and yeah, and I learned that. I sort of sensed it, but I learned it from my friends in Finland. My conference when I was for IESA was in Helsinki, and the Finns told me the same thing. They said the kids grow up learning either English or Russian, and they do it because they want to learn English to be closer to America, but they learn Russian out of necessity because of their border situation. So,
Right.
in other words, it was a necessary part of living in Finland or in Scandinavia, because if you want to do international business, nobody is speaking necessarily Norwegian or Swedish. They're speaking English, and that was the language that, French and English, of course, were the languages of the United Nations and the EU and so forth. And so that process made it a necessary thing to learn either. And I'll tell you one thing. At one time, I think the EU, they said 90% of the papers were in French, and today it's 90% are in English.
Right, right. Yeah, there's been a huge turnaround with that.
Yeah.
In French, they were kind of, you can learn it, but no, people don't really use it anymore. I'm like, I went through all this for a language they don't use anymore. Malcolm, this has been so interesting and fun, and I have really enjoyed our chat today, as well as our chat about James Bond. If you need to know any trivia about James Bond, he is the guy to ask. So Malcolm, thank you so much. I really enjoyed this today.
Thank you for having me, Hillary. It's been a joy on my side too. Be safe and well.
Thank you.